where the Supreme Court today stripped key provisions from the historic Voting Rights Act. The five-block conservative majority said that even though discrimination during elections still exists, it's now up to Congress to decide which districts warrant federal intervention. And that would be an insurmountable task for a legislative body that is dysfunctional on its best day. NBC Justice correspondent Pete Williams is live at the Supreme Court. Pete, take us through this. The decision, the reasoning of the court was certainly hinted at broadly in the oral arguments last October.
4 years ago, Andrea, in a similar case, the Supreme Court came very close to striking down the Voting Rights Act and rattled its saber and said to Congress, things have changed in the South. The pervasive discrimination that existed in 1965 is a relic of the past. Congress has got to update this law. Congress did nothing, so it should surprise no one that the Supreme Court has done what it threatened to do 4 years ago and today blew a crippling and potentially fatal hole in the Voting Rights Act. Here is, I think, the best way to understand the court's logic. They say the Voting Rights Act upsets the normal balance between the federal government and the states. The states normally, under our Constitution, get to decide how elections are held. The federal government in the Voting Rights Act presumes any change at all in elections in the states covered by the law to be improper. The states are guilty until proven innocent. They have to get permission from the federal government in order to make changes. So the Supreme Court says, you know, when we have upheld the Voting Rights Act in the past, we did so because discrimination was such a huge problem that it justified that kind of upset in the normal balance between the federal government and the states. That no longer is the case, the majority said. They cite Census Bureau numbers from a recent election showing that the African-American voter turnout in 5 of the 6 states in the South covered by the law is higher than white voter turnout. So they say Congress needs to adapt the law if it's going to continue to be constitutional, and because it hasn't, it has to be struck down. So in theory, the part of the law that says you have to get permission before you make changes, that's still good. It's the question of who's covered by the law that is now back up to Congress. And in the meantime, that section, the most important part of the Voting Rights Act, is dead in the water.
This is what the Vice President had to say about working with Congress to make these changes.
We're going to work with Congress in this effort, and the administration can do everything in our power to ensure fair and equal voting processes are maintained. So there's a lot of work that's going to have to be done, but it's nonetheless disappointing that the court made the change.
Now, we know how dysfunctional Congress has been in every aspect, Senate versus House, and disagreements within parties as well. Let's go over some of the states here that are involved in the states that are affected by this decision. We're talking about the entire state of Texas, South Carolina, Georgia, Louisiana, Mississippi, Virginia, Alaska, Arizona, Alabama, and parts of these states, Florida, North Carolina, New York, South Dakota, Michigan, New Hampshire. So this is not only the Deep South. These are areas that have been found in the past to have been held by the federal government to discriminate or act in ways that disaffect minorities in their ability to register and to vote.
And not just racial minorities, because the law has been changed over the years since it was passed in 1965 to include, for example, language minorities. So it captures Native Americans in the Southwest. It captures parts of Alaska. So, yes, but it's predominantly the South. That's where the problem was. And if you think about the political climate in 1965 that led to this law, it's nothing like that now. Now, what the dissenters say today, and this was a 5-4 decision along the usual lines, the majority written by the Chief Justice, Ruth Bader Ginsburg, writing for the minority, says that it's still a pervasive problem. The Supreme Court, it says, is ignoring the fact that things have improved in the South because of the Voting Rights Act, and it has to be kept in order to basically keep these things that are only vaguely underground from bubbling back up again. And the dissenting opinion, which is actually longer than the majority opinion, cites a number of continuing problems with attempts to make it harder for African American and other minorities to vote.
Pete Williams, thanks so much. Thanks for that perspective, and it is the exact proper introduction for Georgia Congressman John Lewis. who has been a national leader in the civil rights movement, of course, from the beginning for 5 decades, was there when President Johnson signed the Voting Rights Act into law in 1965. Dr. Martin Luther King Jr., of course, was there, who put his life on the line in Selma to try to get that law passed. You join us now from Capitol Hill. Congressman, your immediate reaction to basically gutting the central enforcement mechanisms of the Voting Rights Act?
Well, I must tell you, I was disappointed because I think what the court did today is stab the Voting Rights Act of 1965, and it's very hard. It is a major setback. We may not have people being beaten today. Maybe they're not being denied the right to participate or to register to vote. They're not being chased by police dogs or trampled by horses. But in the 11 states of the old Confederacy, and even in some of the states outside of the South, there have been a systematic, deliberate attempt to take us back to another period. And these men that voted to strip the Voting Rights Act of its power, they never stood in unmovable lines. They never had to pass a so-called literacy test. It took us almost 100 years to get where we are today. So will it take another 100 years to fix it, to change it? I call upon my colleagues in the Congress to get it right, to fix it. When we renewed the act in 2006, only 33 members in the House voted against it, not a single member of the United States Senate. And it's based on testimony, on research, and what has taken place in the past and what is still going on today.
But Congressman, as you know better than I, there is a lot more disagreement in Congress in both houses today than even a few years ago. So what are the chances of mobilizing majorities to get this through, especially with the supermajorities that are required to even get something on the floor in the Senate and the Hastert rule in the House?
It's going to be hard. It's going to be very difficult, but people said the same thing in 1965. Because of what happened on Bloody Sunday, because of the murder of 3 civil rights workers that I knew, Andy Goodman, Mika Sherner, and James Chaney, just 49 years ago this month. We must not forget our past. We must not forget our history. If we forget it, we will repeat it.
This August is going to be a very important anniversary of the March on Washington, when Dr. Martin Luther King gave the great speech on the Mall and you were standing right at his side. Will this mobilize even more people to come to Washington, do you think? Should this be the spark to reignite that?
I think what happened today with the Supreme Court will motivate hundreds and thousands of people, African American, Latino, white, Asian American, Native American, men, women, students, to come out. The vote is precious. It is sacred. When I spoke at the March on Washington on August 28, 1963, 50 years ago, I was reading a copy of a newspaper and I saw a group of women in Southern Africa carrying signs saying, "One man, one vote." And I said, "One man, one vote is our cry. It is ours too, and it must be ours. And it's more relevant today than back in 1963.
What is your message to the Supreme Court?
My message to the members of the United States Supreme Court is, remember, don't forget our recent history. Walk in our shoes. Come and walk in our shoes. Come and walk in the shoes of those 3 young men that died in Mississippi. Come and walk in the shoes of those of us who walked across that bridge on Bloody Sunday, March 7, 1965.
Did you think on that day when Lyndon Johnson signed this into law that 5 members of a Supreme Court, the majority, would someday gut it the way it has today?
I didn't think that on that day when President Johnson signed the Voting Rights Act, that I would live to see 5 members of the United States Supreme Court undoing what President Johnson did with those pens. And I had one of the pens that he used to sign that law, at my home in Atlanta, and when I get home, I would pick up that pen.
And perhaps you could write a note to one of the justices.
Well,
Mr. Lewis.
Thank you.
Thank you very much, Congressman. Thanks for being with us. As you know, it's always a privilege to talk to you.
Well, thank you so much.